I'd probably expect him, you'll probably be seeing him in the next month, April or so, but I'd ask to leave this on for the 5/8 docket as a catch back up.
Okay. Mr. May, I'll see you no later than May 8th. Thank you, sir.
Destin Russell.
Judge, this is Destin Russell before the court and 22 CF 2232. We're trying to ascertain where we're at with the state with this case, and also he's got a case in Escambia County, which may be more serious than this one. So for today, I don't believe we're in a position to enter a plea agreement. I know Mr. Russell wants to get to Escambia County as quickly as possible. I'm going to discuss with the state.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100.
At this point, our offer would be the guidelines, which is 59.475 months Department of Corrections.
Mr. Russell, do you agree to the continuance?
Yes, sir.
Okay, I'll see you back here no later than May 8th.
Judge, if we're able to reach an agreement ahead of time, or if we're able to get him over to Escambia for some reason, then can we reach back out to the court, get onto an earlier docket?
Absolutely, yes, sir. As early as Thursday next week, the week after that, or early April. Yes, sir.
This is Joshua Salerno.
Did you have a chance to read that?
Yeah.
48 hours community service. Substance abuse elimination, anti-theft course, no trespass. That was 2 places. The restitution will be ordered, and you would have to have Mr. Defendant.
Wait, I still want you to know his name.
And they would be paid through probation.
Why do that? You want to know?
Yeah. Put his name in the record. So that's what you want to do?
No.
Okay. And you've had time to read this through? Okay. Judge, Mr. Salerno is back. We are going to be entering a plea in both case numbers, which are 22 CF 772 and Madam Clerk 23 CF 300. State 32022. The agreement that's been reached is for an adjudication of guilt in all counts. Mr. Salerno is going to be placed on a period of probation for 5 years. There is an automatic early termination provision if he's able to complete all requirements after the 2-year mark. In the 23 CF 300 case, there's going to be a restitution amount established in the amount of $12,000. You're going to come out through that.
Judge, that's going to be the Suraj Patel, Surajpatel, and have to get Madam Clerk an address.
Is that the attorney, Shiraz Patel?
No, that's,
He's
it's not
receiving
Shiraz, it's Suraj.
Okay, thank you.
Additional special conditions are going to include 48 hours community service work, a substance abuse evaluation, and any recommended treatment, an anti-theft course, no trespass at 13 Miracle Strip Parkway, and also no trespass at Big Iron Environmental. Any questions? Okay. May I approach?
Please. Mr. Salerno, if you'll raise your right hand.
Do we need probation here?
Yeah.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You put your hand up.
I mean, I have copies of this.
Does the court want to move forward without probation here?
You can always let them know what happened. We'll do that.
Okay.
Yes, sir. Mr. Salerno, did you read the plea agreement?
I did.
Do you understand it?
I totally do.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Very well.
Are you satisfied with his representation?
I am, very much.
Did you sign the plea agreement?
I did.
Mr. Salerno, I do accept your plea. You're adjudicated guilty in both cases in each count. You're sentenced to 5 years probation. However, your probation may terminate at any point after the 2-year mark if you've successfully completed all the terms of your supervision, including the paying the restitution, and haven't committed any new law violations.
Right.
You'll need to perform 48 hours of community service work, pay the restitution in the amount of $12,000, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. Enter and successfully complete the anti-theft course, have no trespassing at the 2 locations that Mr. McKinney stated today on the record. It's a total of $250 public defender's fee, also $40 per month cost of supervision. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. Thank you, sir. Good luck to you.
Judge, would the court consider waiving the cost of supervision given the $12,000 amount of restitution?
Mr. Salerno, how much money were you making before you were incarcerated?
I was this close to start my own tree business, and, so,
Okay.
but before that, not so much.
I'll waive the cost of supervision for the first year, and then you'll have to pay it after that.
Thank you.
Okay?
Thank you, Judge.
Thank you, sir.
You're Mr. Salerno. Next is Kamani Smith.
Judge, this is Mr. Kamani Smith. He is here in 22 CF 2169.
Yes, sir.
He met with D. Adams from Mental Health Court last Friday, and he's been placed on the Mental Health Court docket for April 5th. So he may come off of our docket as he observes that program. I believe that program would be a good decision or a good result for Mr. Smith, given the structure that it provides. His mother was present here today, so she wanted me to know that she was here for you earlier. But I'm going to ask for a continuance today, understanding that he is going to be going and observing mental health court on April 5th.
Mr. Smith, mental health court has a lot of different tools that I don't have. Pretty cut and dry in felony court about what we can do and what we can't do. But mental health court, as Mr. McKinney alluded to, they really stay on you. They give you a lot of things that you have to do, but at the end of that, if you successfully complete it, your case is dismissed. It's dropped, okay? Great outcome. You don't have to worry about wondering any lingering effects of this case. So they'll keep you very busy. They'll watch you a lot. I mean, not physically, but they'll just stay in touch with you. But they have a lot of different things. You know, if you don't do something, the court can do things in increments versus this is just kind of an extreme. So I hope that you get in mental health court. Hope you accept it. If not, then I'll see you back here on May 8th. Okay?
Okay, we'll take some details on that program, meaning that I'll be with you going to that program on the 5th of April.
Next is Eric Smith.
Details of the program that is, not today, no.
All right, Ms. Wade, Mr. Smith. Next is Eric Smith.
Judge, this is Mr. Eric Smithwick before the court in 22 CF 680. And I wanted Mr. Smithwick in the courtroom so that we could make some good record of where we're at with his cases. Because this is the other individual in which I'm having issues with a digital forensic expert. And I've discussed that with Mr. Smithwick. We've discussed how we'd be able to use an expert in the courtroom, how it would affect his case at a trial, and making our determination whether or not we wanted to seek a second expert, and we are. as we try to get prepared for the next trial cycle. So I'm going to be requesting a continuance until the May 8th docket, but I wanted the opportunity for everybody to be in the same courtroom at the same time in case Mr. Smithwick had any questions or if the court had any questions about where we're at with these cases.
Okay. Mr. Smithwick, this morning we talked about another case that was similar. Certainly when Mr. McKinney brought it up this morning, I remembered all the problems that he's had with that expert in the past. Frustrating to the court, not as much as you because you're incarcerated.
Yes, sir.
But I understand what he's trying to do. Mr. McKinney, you've identified someone?
Yes.
Good.
And I've discussed that with Mr. Smithwick.
Okay. Mr. Smithwick, do you agree to the continuance?
Yes, sir.
Okay. I'll see you back here no later than May 8th.
Okay.
Thank you, sir.
Thank you,
Next,
Thank you, sir.
Adam Stevens.
Hello, Mr. Stevens.
How you doing?
Good, how are you?
Judge, this is Mr. Stevens before the court. We were on the trial docket and we've announced ready for trial.
Okay.
This is 22 CF 2583.
Yes, sir. So, Mr. Stevens, we're scheduled to go to trial next week. I'll see you back here on Thursday. If there's any offer from the state, they traditionally withdraw that on Thursday. So you decide between now and then if you think it's in your best interest to accept that offer. If not, then we'll be going to trial either next week or the week after. Okay? So I'll see you Thursday. Thank you.
Next is Peyton Thomas.
Hello, Mr. Thomas.
Judge, this is Mr. Peyton Thomas before the court in three case numbers, 22 CF 410, 22 CF 471, and 22 CF 543. This is on the trial docket. I would procedurally note that the state has filed an amended information in at least two of those cases. I provided or printed off copies of those informations to provide to Mr. Thomas. So in 22 CF 410, we would acknowledge the receipt of a one-count information and waive its formal reading in our plea of not guilty. And in 22 CF 543, we would acknowledge an amended information, waive its formal reading in our plea of not guilty in that case as well. What this has done is, so Mr. Thomas is now, instead of being charged three separate ways, he is charged as burglary of an unoccupied dwelling in each of the three cases. So this is on the trial docket because we were trying to gain some sort of a resolution here, but we remain ready for trial.
Okay. To the state, which case are you going to try?
Judge, I know Mr. McKinney and I had discussed this already, and I think it was the 471 case, did that sound right? The files are with, I'm going to have Mr. Noah Hearn from my office, he's going to be trying the case on behalf of the state.
That was the one that was original defrauding an innkeeper.
And Judge, as we come back for Thursday for jury trial review, then I'd certainly like notice on exactly which case the state's willing to go forward with. I believe it would be probably the 471 case in which the state is referencing.
Okay. So, Mr. Thomas, I'll see you back here on Thursday. If the state's made an offer to you, they traditionally withdraw it on Thursday. So if you want to accept it, you'll need to do it by that date. If not, we'll be going to trial in the next couple of weeks.
Judge, to be clear, I haven't received any kind of counter offers from the defense on this case or anything, so there hasn't been exactly any more plea negotiations than what was initially offered on the cases, so.
Okay. What is the outstanding offer? to Mr. Thomas.
I think Mr. McKinney has everything.
Judge, we had contemplated or asked for a reduction to burglary of structures prior to the state amending the information in 2 of these cases. So there's now 3 charges for burglary of unoccupied dwelling. I don't have an updated score sheet given the changes being made in how Mr. Thomas is charged. However, I would expect that the score sheet would be going up, not down, based on the burglary of unoccupied dwellings. Mr. Thomas did score approximately 44 months. We had discussions with the state prior about asking for a non-prison sentence and reduction of burglary of a structure. But I will be meeting with Mr. Thomas tomorrow in jail, and then we'll remain ready for trial if we're unable to resolve it.
Okay. Thank you, sir. I'll see you Thursday. No, I'm not worried about, I'm worried more about you than I am about my time.
Oh, saying something.
If you say anything factually about your case, it can be used against you, and everything's recorded, so. So do you want to ask Mr. McKinney away from the microphone before you say anything?
Yes.
Why don't you? See you Thursday.
Judge, Mr. Thomas's question was related to plea negotiations and just hoping for a reduction in charges. So we'll see the court again on Thursday.
Yes, sir.
Next is Michael Thompson. Go ahead and open the door.
Judge, this is Mr. Michael Thompson before the court, and 3 case numbers, 22 CF 1332, 22 CF 27, and 21 CF 2624, which is a felony violation of probation. Judge, we had set this case over today in attempts to resolve the matter. Mr. Thompson was hoping to be entering a plea to something that is non-state prison. We have not been able to secure that offer from the state, so I'm going to request a continuance until May 8th. And if there's any motion practice or any additional court dates that we need, we can inform the court.
Okay. Mr. Thompson, do you understand what Mr. McKinney's doing on your cases? Okay. Mr. McKinney, what are you going to do over the next couple months?
Judge, we completed depositions. I discussed that with Mr. Thompson and how that may relate to a motion to suppress. Mr. Thompson is hoping to avoid that through negotiation with the state. We have not been able to reach something that's a non-state prison sentence. He does score on the current score sheet. So we need to negotiate with the state and determine whether or not we're going to file a motion to suppress in his case, or whether or not we're going to go forward with an evidentiary hearing for the violation of probation and ultimate jury trial if we choose to go that route absent negotiation.
Okay. So you'll file a motion before May 8th if you're going to file one?
Correct.
Okay.
We completed the depositions. We're not in time to file any motions prior to this cycle on Monday or today.
Okay. Mr. Thompson, I'll see you no later than May 8th, but if Mr. McKinney files a motion before that date, I'll see you then. Thank you.
Next is Mark Triplett.
This is Mr. Triplett before the court in two cases, 22 CF 2986, 22 CF 2603. And Madam Clerk, he has a third case now, which is 23 CF 549, which is set for arraignment on April 13th. We have been in discussions with both Walton County and the state here about resolving these matters to get Mr. Triplett to Walton County as quickly as possible. We may be able to do that. However, the state attorney has not had an opportunity to review or file on the 23 CF 549 case. So there's currently no information filed if we were to attempt to enter a plea right now. So what I'd like to do is procedurally continue the cases set for today. Keep the court date that is set on the 13th of April. And then, Madam Clerk, could we add, would it be problematic to add these two case numbers to his arraignment date as status so that all of his cases are set on the next available date? Or is that going to create issues?
I think it'd be kind of strange to put something else that's not an arraignment on the arraignment date.
Sure.
So the arraignment's on April 13th?
Correct. I just want to keep the next available court date for Mr. Triplett if we're able to resolve the cases and enter a plea in all three.
Okay. Let's just put them on for May 8th. But again, if you want to schedule up something before that date, I'll see you on April 13th on the arraignment, the new case. But then if you want to enter a plea or you want to do anything different, in all three of the cases, Mr. McKinney can make sure they're running together. If you want to enter a plea on April 13th, Mr. McKinney can make sure that that works. Okay? Thank you, Mr. Triplett.
Matthew Warner is next.
Hello, Mr. Warner. Yes, sir. Good afternoon.
Judge, this is Mr. Matthew Warner. Mr. Warner is here in two cases, 22 CF 1917 and 22 CF 3120. The court wanted Mr. Warner to be here today because I had not received the discovery in 22 CF 3120. Last week I did receive a good portion of the discovery, including a witness list that's going to lead us to depositions. That was the court's concern at pretrial. So I'm going to request a continuance, as I did at pretrial, to May 8th so that we can set and complete depositions in the 3120 case now that we have a good portion of the discovery.
Okay. Yes, ma'am.
I just want to make the court aware of the situation. It was completely on me that I had missed doing the discovery on that case. There was another case that had come in on Mr. Warner, and so when the file came back to me after I had filed the information on the case, when it came back, that other file was on top of it. So I did all the intake for the newest case and missed that there was another one that I hadn't finished doing everything on. So it's completely my fault.
Mr. Warner, I'll see you no later than May 8th.
No later than May 8th?
Correct. If Mr. McKinney wants to set a hearing before that date, he can do that.
Okay. I'd like to have a copy of it to go over as well.
Yes, I'll get you a copy of the discovery.
Both discoveries if we can.
Okay.
Okay, all right, thank you.
I don't want to give my other copy right now, but I'll bring you up a copy when I can see.
Yes, sir.
Okay.
Lorraine Williams.
Yes, sir.
Well, Mr. Williams.
Judge, this is Mr. Lerone Williams before the court in 22 CF 2258. Judge, I was appointed to Mr. Williams' case on Monday. May I have just a moment? Do you have a copy of the information? based on our conversation last week, if that's still what you want to do. The two things you charge with, right? If you don't have a driver's license and the fingerprints and so on, this is a felony. That's what causes you to be a problem with immigration. It would go down from the students, which is better than it would be to the city. Immigration, or not recommendation. And Judge, I hustled to get up to see Mr. Williams since I was appointed on Monday of last week. We did discuss his case and go through some immigration consequences if he were to enter a plea. The agreement with the state, if Mr. Williams chooses to accept it, would be to enter a plea as charged in count 1, which is a second-degree misdemeanor, and plea to a reduced charge in count 2 to resisting without violence, which is a misdemeanor. The agreement would be time served. However, Mr. Williams does have a current ICE hold, so I have advised him that even a plea to a misdemeanor is something that can be used and will be used against him in a deportation proceeding, and that he shall be deported by entering a plea. So that's something that is certainly up to immigration, but there are certainly consequences that Mr. Williams understands as part of entering a plea even to a misdemeanor.
The adjudication's guilt of the misdemeanors?
He would be adjudicated guilty of the 2 misdemeanors. The state would take no action on any FTA.
Mr. Williams, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Williams, so do you understand that if I accept your plea that you're waiving your right to a trial by jury?
Yes, sir.
You understand that you'd be adjudicated guilty of the 2 misdemeanors?
Yes, sir.
Okay. Mr. Williams, I used to tell people that had immigration questions, I'd say, do you understand that by entering this plea you may be subjected to deportation? A few years ago I read an appellate case that said I should be saying, and I'm not a federal court, I'm a state court, so I don't do immigration, but the appellate court said that I'm supposed to tell you, do you understand by entering this plea you shall be subject to deportation? So do you understand that?
Yes, sir.
Okay. Do you still wish to enter the plea?
Yes, sir.
Mr. Williams, go ahead. Do you have a question for me or Mr. McKinney or the state?
No.
Okay. I'm not somebody that pulls that trigger and says, go deport anybody. But since Mr. McKinney said that you got an ICE hold, they're going to know this. So, Mr. Williams, I do accept your plea. You're adjudicated guilty of the 2 misdemeanors. You're sentenced to credit for time served. You'll need to pay the court costs, the $150 public defender's fee. How long, Mr. McKinney, does Mr. Williams want to pay those amounts, or does it matter?
Judge, let's ask for 90 days.
Okay. So, Mr. Williams, if you don't pay those financial amounts within 90 days from today, then they'll go to a civil lien or judgment. Okay? Not criminal, but civil. Thank you, sir.
Next is the Wendell Wright.
Thank you.
Judge, this is Mr. Wendell Wright before the court in 21 CF 1776, 20 CF 3187, and 21 CF 1772, and 20 CF 2804. I received a mitigation package and a mental health report from Dr. Zeman over the weekend. I haven't even had a chance to read it yet. Certainly haven't had a chance to provide it to the court or to the state to see how that affects our negotiations. I would like an opportunity to review that with Mr. Wright and prepare potentially for sentencing. I would request a continuance until May 8th. This was set plea or continue because we were awaiting that report.
Okay.
Judge, I have made an amended offer that is lesser charges, below guidelines, everything. At this point, if the defendant does not accept that offer by the end of April, it's not going to be there come May 8th. It's been outstanding now for quite a while, and I think at this point, a decision needs to be made, or we need to start going to trial on these cases and start whittling through them.
Okay. So, Mr. Wright, my job isn't to talk you into anything. I don't even know what the state's offer is. But you heard what the state said. If you don't accept their offer by the end of April, then they intend to withdraw it. I'll see you back here on May 8th. Mr. McKinney can set you up. If you say, I want to take the offer Thursday, he can bring you back on Thursday. If it's next week sometime, he can set a hearing for then or the week after that. But just know that that's what the state's intention is. The separation of powers doesn't allow me to make them hold an offer open no more than it allows me to tell you you have to take it. So just be aware of that, okay? Thank you, sir.
All right, man, have a good day.
You too.
Have a good day. Thank you.
Kavanaugh Harris. Your Honor, we have Friday's representation.
Okay.
The same goes for.
Therese Cruz. Mr. Harris, have you communicated with your attorney lately? Has she communicated with you?
My family did, and he was supposed to be turning up. I'm not sure what happened again.
It's he? Okay. So he's supposed to be representing you?
Yeah.
Okay, let's see if we can. See if we can find a number for him. To the state, you don't have a number for Mr. Cruz, do you?
No, I've never had any contact with Mr. Cruz.
I do see one on the notice of appearance.
Yes, ma'am, that'd be great. That's where I was going to look.
Okay. 409-494-5341.
5341. Okay. See if we can get Mr. Cruz on. If he can hear us through this thing. Okay, what I dialed was 409.
Try.
This is Attorney Cruz.
Yes, this is Judge Brown. You're Mr. Cruz?
Yes, Your Honor.
Mr. Cruz, can you hear me okay?
Yes, Your Honor, I can.
Good. I've got you on speaker in the courtroom. Your client, how do you pronounce your first name? Kevon? Kevon Paris is here with me, and you're not.
Yes, Your Honor.
I was just curious where you were.
Excuse get that. May I jump on your Zoom right now, Judge? I didn't get that notification, but I'm in the office. I can jump on right now.
Okay. Do you know what that
Yes, Your Honor.
number is?
Yes, Your Honor, I do. Thank
Okay.
you.
Yes, sir. I'll see you in a moment. Okay, let me pull it back.
Have you tried 470?
Here it comes. Oh, that's the Zoom card. Here again, under Attorney Cruz. Can't hear you, Mr. Cruz.
Yes, Your Honor.
There we go, now we can. Okay, and we'll see if they can get the camera. Allison, the camera's kind of askew. Good, thank you, sir. Yes, sir, Mr. Cruz.
Yes, Your Honor. Good afternoon. For the record, Attorney Tyrese Cruz, representing Mr. Kevon Harris.
Yes, sir. What do you want to do with Mr. Paris's case?
I wanted to see whether or not the state, I know the public defender had mentioned that there was an offer. I wanted to see, I left a number to get a call back whether or not the state had an offer, potentially to see whether or not we could resolve this without going into depositions. And if that was not acceptable to the defendant, then we could move forward with getting prepared for trial.
Mr. Gomez, an offer to Mr. Paris?
As of right now, for just this 22 CF 2196 case, the offer would be 36 months incarceration with a restitution amount that would be to determine reserved for 180 days. However, I am aware that there is also another case that's coming down that from what I understand from Crestview, that concerns a battery in the jail. So I think it probably, given that we haven't made depositions on this case, this particular charge is an arson. So there is quite a bit of depositions and discovery that I imagine would need to be conducted before we're at a place where we could resolve it. I think setting it for the May 8th date would be the most appropriate, so that we can also make sure that we get the other case that's going to be, it's already been filed, it's on its way down from Crestview, so we can get that case as well and hopefully reach a resolution for both of the cases.
Okay, so Mr. Cruz, do you agree to continuance until May 8th?
Yes, Your Honor.
Okay. Mr. Paris, do you agree to the continuance?
Yes,
I'll see you back here no later than May 8th. If your attorney wants to set a hearing before that date, he can, okay? Thank you, sir. Thank you, Mr. Cruz. If you'll make sure you attend promptly next time.
Yes, Your Honor. Is this notice? My apologies, Your Honor.
Thank you, sir.
I have another inmate, that the attorney did not show.
Okay.
And that is Nathaniel Briggs.
Briggs.
If we want to get that one ready. I also last inmate other than Riggs is Salter, which is the case that we were waiting for the.
Okay, well, that was until 2 o'clock and it's after 2, so,
They're in the hallway, in my understanding.
oh, okay.
So I'll give them time. We'd rather have the max come in so we can find out the attorney there.
Meaning Riggs?
Yes.
Yes, ma'am, that'd be fine.
JJ, you can put the Riggs on the.
Oh, okay.
Well, Mr. Riggs, we're trying to get your attorney on Zoom or on the phone, so if you'll just give us a second.
The attorney now is Brad Stewart.
Who is that?
Brad?
Judge, this was the case, Mr. Buck,
He was
there's some.
removed.
Right.
Mr. Buck
Okay.
was removed. The court appointed Brad Stewart. Zach, because this is Mr. Rogers' case and he was in another courtroom, he stated that he had submitted a proposed order to the court stating this last Wednesday, but we had not seen anything to be granted yet. The case was set for today so that Mr. Stewart could speak with the defendant before today. There hasn't really been anything, to my knowledge, because of the situation with the previous attorney, there hasn't been much done, so it's going to take quite a bit for Mr. Stewart to get up to speed. And we think, given that we haven't seen Mr. Stewart in court today, and he normally is on top of his cases,
Yes,
that he might not have known that he needed to show up today. Because if I'm not mistaken, he was not in the courtroom when he was appointed. We had gone through the list, and I think that was how we decided on Mr. Stewart. But either
And
way.
you sent me a proposed order and it hadn't been signed?
I believe ASA Rogers did. And he said he had not seen anything back as of today, but that he believes that the best course of action would be to set it for the next pretrial docket.
Okay. Mr. Riggs, I don't want to wait a couple months to see you again. I want to make sure that Mr. Stewart gets up with you. So we'll set your case for Thursday at 9 o'clock, okay?
Yes, sir.
And I'm going to follow up right after I get off the bench and let Mr. Stewart know.
I just sent Mr. Stewart a message right now.
Great, thank you.
Like I said, he wouldn't have received notice from the clerk. He wasn't put in until I just now put him in. So he will receive the court date by us tomorrow morning.
Okay, so I don't need to contact Mr. Stewart, it sounds like. Okay, so, Mr. Riggs, I'll see you on Thursday. Mr. Stewart will communicate with you then or before then, and then we'll talk about your case. Okay?
Okay. Yes, sir.
Thank you, sir.
Your Honor, while they're confirming about Mr. Salter.
Yes, sir.
Could I approach with an order on Cameron Boswell?
Sure.
I talked with the state this morning. Mr. Boswell was kind of confident to proceed by the court a couple of weeks ago.
And Madam Clerk, I would ask, I looked on benchmark and both of Mr. Boswell's cases still indicate that they're closed. They should be reopened.
Case number?
There's two of them. There's 21 CF 2944 and 21 CF 2589. We just need to get those back on a regular docket. I would ask the court to continue this to the May 8th docket. But I talked with Mr. Gomez this morning, and Mr. Gomez would agree that on behalf of Mr. Boswell, I would request the court reinstate Mr. Boswell's bond in the 2589 case, and then in the 2944 case, there are two current $2,000 cash professional bonds. The or tennis motion would just ask to reduce those to $2,000 signature bonds. Mr. Boswell's already on mental health pretrial services. I'm not asking the court to do anything with that. Just essentially to reinstate, all those bonds in the 2589 case are already signature bonds. So the intent really is to get Mr. Boswell to sign himself out. I've talked to the alleged victim in the case, who is actually a Fort Walton Beach police officer, but as an individual homeowner. And so I think we're going to get this worked out with some kind of a plea involving restitution. But in the meantime, Mr. Boswell, he's got some mental health issues, and his mother has taken time to get some appointments set up for him. And so we've just asked the court to grant the motion and sign the order.
Okay. So the proposed order says that the previous...
Judge, just for the record, just for efficiency, he sent it to me and I stipulated to it, so.
Okay, and I'm signing it now. And his 2 cases are continued until May 8th.
Thank you, Your Honor. And I've been as clear as I can with his mother, either by Zoom or in person. We need him here on May 8th, one way or the other. So. And then I'll turn it over to
What else do you have, Mr. Collins?
If you guys are ready to solve it. I've got about 5 or 6 cases of people that weren't here this
Yes, sir.
morning.
You want to do them now?
Okay, that'd be great, yes. So on one, Denzel Green, I've had no contact with Mr. Green.
State requested case, Your Honor.
KPS will be issued for Mr. Green, and the first appearance judge will determine the bond.
I do have a misdemeanor plea for Isaiah Hazlett, if I may approach.
Yes, sir. Thank you.
And this is going to put Mr. Hazlett on 1 year of probation. Do you want me to announce it, or do you?
Who's going to do it? Is probation doing it?
JCS is going to do it.
Okay.
And Mr. Hazlett's already been given contact information and instructions to call him on Wednesday.
No, sir, then I think it's fine, just in writing.
Yes, sir.
Yes, sir.
Next, I have Johnny Lee. Mr. Lee is not present.
What is this?
State requested case, Your Honor.
KPS will be issued for Mr. Lee. Unless it's something contrary, it'll be the first appearance judge. Thank you.
Next, I have Colby Knight. Mr. Knight was announced for your trial. His mother actually contacted us and informed us he was arrested last week in Alabama. So I would ask the court, if the court's going to issue a KPS, just don't restrict Mr. Knight's bond. He's been in pretty good contact in my office until his arrest. So.
Okay. KPS will be issued for Mr. Knight. It will be a no bond.
No, I'm asking the court to not restrict the bond. I don't want to call it without bond. I think the issue is just getting him notice of his next court date once he's transferred to the county jail.
Okay. So the first appearance judge will determine the bond.
Okay, the bond is known as Julie?
Correct.
Next, I have Alyssa McGinnis. She was on last week's docket, Your Honor, and I did not realize we had filed a waiver. I actually have an appointment scheduled with her on April 11th at 1 p.m. So I would ask for 1 second continuance on that.
Yes, sir. It's continued.
Next, I have Elijah Leroy. See Mr. Leroy.
State requested case, Your Honor.
KPS will be issued for Mr. Leroy.
Next, I have Joshua Mills. I don't see Mr. Mills.
State requested case, Your Honor.
KPS will be issued for Mr. Mills.
Next, I have Jamie Mood. I don't see Mr. Mood.
State requested case, Your Honor.
KPS will be issued for Mr. Mood.
Next, I have Israel Mount. I filed a waiver of appearance on March 14th. We're just trying to figure out who we need to be making these payments to. So I would ask for one side of continuance, and I'll give Mr. Gomez to figure out how to make these payments.
Mr. Gomez, you okay with the continuance?
Yes, Your Honor.
It's continued one side.
Next, I have Billy Nichols. Mr. Nichols is in the Bay County Jail. He was announced for your trial. I'll leave him to the court.
So on Nichols, are we going to transport him and go to trial?
He's got new charges there. He actually has an arraignment date today for Mr. Nichols. So I would just ask for issue for the case.
Okay. KPS will be issued for Mr. Nichols.
And then Crystal Owen, she was only on today's docket, so we could get pain dismiss information. I would ask for a 1 second continuance from Ms. Owen. She was in court last week.
What did you need?
We need to figure out who to pay. It's been a pain dismiss.
And I will get on it. I just admitted that I've been more worried about calling victims and stuff like that for the cases set for trial. So if we can, we'll definitely get off the docket before the May.
Good. Thank you. It's continued.
And then the last one that I have this morning, Your Honor, is Darby Boudreau. She was announced for your trial. I don't know where Ms. Boudreau was, but this is going to be a PTI in the same vein of the member of the clients this morning. So I would ask for the court will put Ms. Boudreau on the 413 docket since she wasn't here today.
Why shouldn't she be here on Thursday?
I can see if I can get her here on Thursday.
Why don't we do that?
Okay, good. And I believe that's all I have.
Okay, good, thank you.
Thank you, I
Mr.
appreciate
Cole.
it. John.
Thank you.
Judge, I believe that's also all I have. That makes it.
Yes, sir, thank you so much.
Next is Salter.
Thank you, Mayor. So-